And today, the Supreme Court has answered that question by a vote of 6-3.
The U.S. Supreme Court has just issued a major ruling.
Major Second Amendment case.
Major Supreme Court ruling.
The Supreme Court just redefined the meaning of your front door. They handed down a 9-0 ruling that, on the surface, clarifies the law, but underneath, it just gave law enforcement a new, broad pathway to enter your home without a warrant. For decades, the Fourth Amendment stood as an almost impenetrable shield. No warrant meant no entry, but today, that shield has a massive new hole in it, a hole that affects every American, especially those who value their privacy and the protection of their property. This landmark case wasn't about a crime caught in progress. There were no active charges, no hard evidence of wrongdoing, and certainly no signed arrest warrant. It began with just a few worried words, a vague call, and a growing sense of unease. The ruling is unanimous. The implications are enormous. Because from this day forward, in specific emergency situations, the requirement for probable cause is officially dead. It has been replaced by something far looser, a police officer's belief that someone might be in danger. This is the kind of seismic shift we need to break down in detail. We have to walk through exactly what happened in that quiet Montana home, why the court agreed, and how this new standard changes the legal landscape for every house, apartment, and dwelling in the entire country. The case that brought us here is Case versus Montana. It settled a single, terrifying question. When can police walk into your home without a warrant? The answer, it turns out, is when they believe they need to save a life. But the danger lies in how easily that belief can be constructed. This entire discussion matters most for law-abiding citizens, especially those who own firearms. Why? Because once law enforcement crosses that threshold without a warrant, they aren't just there to check on your well-being. They can seize firearms. They can gather evidence. They can escalate a private situation into a criminal confrontation, all based on the new standard of objective reasonableness. They no longer need probable cause to justify that initial intrusion. This ruling draws a definitive new legal line. It dictates that under certain circumstances, emergency exceptions, your sacred Fourth Amendment protections may take a decisive back seat to an officer's snap judgment. So how did this all unfold? And how could 9 ideologically varied justices agree on something that seems to erode fundamental privacy? We need to unpack what truly happened in Trevor Case's Montana home and understand the constitutional precedent the court used to justify this entry. The ruling came straight from Justice Ketanji Brown Jackson, writing for the entire unified court. And the message was crystalline. Police do not need probable cause to enter your home if they have an objectively reasonable belief that someone inside might be in serious danger. That is the new standard we live under. Instead of asking whether there is hard evidence of a crime, the standard of probable cause, the court said officers only need an objectively reasonable belief that stepping inside could prevent some form of serious harm. This is a monumental shift in how the Fourth Amendment is applied during emergencies, and it absolutely lowers the bar for a warrantless entry in every state. But what exactly does that phrase, objectively reasonable, look like when the rubber hits the road? Let's break down the incident that started the whole legal firestorm. The Supreme Court didn't just rule, they overturned the confusing approach used by Montana's highest court. Montana had previously tried to apply a much weaker standard, mere reasonable suspicion, to justify the warrantless entry. But the justices threw that out entirely, calling it the wrong legal test. Instead, they locked in the tougher but still constitutionally flexible benchmark of objective reasonableness derived from the Brigham City versus Stewart case. This means that from now on, courts must ask a simple question. Would a typical, well-trained officer in the exact same situation genuinely believe someone inside was in immediate danger? The question is about urgency and safety, not about suspicion of a crime. Using that specific lens, the court ultimately found that the officers were justified in entering Mr. Case's home. And as a direct result, everything they found inside, including the firearm that led to his conviction, stays in evidence. The chain of events began with a phone call, a call rooted more in raw emotion than in concrete fact. Trevor Case's ex-girlfriend contacted the police. She told them he had called her, and the conversation left her deeply unsettled. She confessed to having a bad feeling. She thought he might have a firearm. She expressed fear that he might hurt himself, and maybe, just maybe, harm any responding officers. Police took this seriously. They drove her to the home with them. But the story quickly became murky. She couldn't remember the exact threatening words Trevor had used. She could only repeat that she felt a crushing sense of unease and believed something dangerous was about to happen. What makes this initial call even more significant is the existing history. These responding officers weren't dealing with an unknown suspect. They already knew Trevor Case. Every one of them had dealt with him before. They were keenly aware of his past struggles with mental health and documented suicidal ideation. They had a history. Based on that uneasy call and the deep well of information they already possessed, officers now had to make the fateful choice. wait for the cumbersome process of obtaining a warrant, or act immediately on instinct, driven by the potential need for aid. When officers arrived at Trevor Case's home, they didn't immediately smash down the door. They didn't rush in. They waited. They waited for nearly 40 minutes. They circled the house. They peered through windows. They called his name repeatedly. Silence. No response. No movement. But what they did observe during that 40-minute stakeout intensified their existing concerns. One officer spotted an empty holster resting on a surface. He saw a notepad. Crucially, he saw what looked like an unsecured handgun inside the home. The internal lights were extinguished. The house was silent. The only small grace they had was that the front door was unlocked. They continued to knock. They used flashlights to scan each room from outside. Still nothing. No sign of Trevor. Just silence and a growing, suffocating sense of uncertainty. Some officers hesitated. Based on prior run-ins and the vague, non-specific warning from the ex-girlfriend, they were unsure what kind of violent scenario they would walk into if they crossed that critical threshold. But after nearly 40 minutes of contemplation and observation, the decision was made. They entered the home. 2 officers moved upstairs. One stepped into a bedroom. Inside that room, he noticed a closet obscured by a simple curtain. As the curtain shifted, Trevor Case was revealed, crouched inside. The officer later testified that he spotted a dark object in Case's hands and reacted instinctively, immediately firing a shot that struck Trevor in the arm and traveled into his abdomen. This single gunshot would ignite the nationwide legal firestorm that led directly to the Supreme Court. Wait, let's look at that again. The officers knew the man had mental health issues. They knew he potentially had a weapon. They saw signs of danger, but they waited 40 minutes. This waiting period is critical. It shows the tension between fulfilling their community caretaker role and respecting the Fourth Amendment. They were investigating before they intervened, but did that 40 minutes destroy the argument for imminent danger? The court said no. The 40 minutes simply built the foundation for the objectively reasonable belief. Silence, combined with the presence of weapons, created an escalating, not diminishing, emergency. After the shot was fired, Trevor Case was detained and placed under arrest. During the subsequent search of the bedroom, officers discovered the handgun tucked inside a nearby laundry basket, just feet from where the confrontation happened. That specific gun, along with other items found in the home, became the central focus of the criminal charges filed against him. He was later convicted on multiple counts, but Trevor Case was not done fighting. He argued vehemently that everything collected inside the home, the evidence, the gun, the statements, should have been thrown out. The officers entered without a warrant, he claimed. Therefore, the search and seizure violated his Fourth Amendment rights, making all evidence inadmissible under the exclusionary rule. The lower courts disagreed. The Montana Supreme Court upheld the conviction in a 4-3 ruling, but this is where things got legally messy and why SCOTUS had to step in. Montana's High Court used a loose legal test, mere reasonable suspicion, to justify the warrantless entry. This approach essentially ignored clear previous U.S. Supreme Court precedent, specifically the Brigham City v. Stewart House case, which had set a much clearer, though different, standard. Because the Montana court misapplied federal law, the case was appealed all the way up. The Supreme Court accepted the challenge. Oral arguments were held. And now the justices have spoken with one unanimous voice. What they said changes how every future emergency entry will be judged by courts across the country. This ruling didn't just settle one man's fate. It fundamentally rewrote the yardstick every court must now use when judging whether a warrantless emergency entry into a home is constitutional. The Supreme Court made it abundantly clear neither probable cause nor reasonable suspicion is the correct test in these urgent life safety situations. Instead, the only question that matters is whether an officer had an objectively reasonable belief that someone inside needed immediate, urgent help. That exact phrase, objectively reasonable, now carries serious weight. It means officers can enter without a warrant, but only if a neutral, reasonable officer in the same position would have believed someone was in immediate peril. It is a standard focused on the optics of danger, not the evidence of a crime. If you're finding this analysis helpful, please take a second to like this video and subscribe to Law Advisor. It helps us keep these deep dives coming. Now, back to the case. When this case landed on the Supreme Court's desk, they had 2 options. One option was to send it back to the Montana Supreme Court and essentially tell them to fix their mistake by applying the correct legal rule established in Brigham City. The second option was to take the facts of this case and apply the correct standard themselves to deliver a final ruling. They chose to handle it directly. The justices reviewed the entire record of the 40-minute stakeout. They applied the objectively reasonable test from the Brigham City precedent, and they ruled that the officers were, in fact, justified in entering Trevor Case's home. That decision now instantly becomes the new playbook for every court in the country dealing with emergency entries. In its unanimous opinion, the Supreme Court ruled that when officers respond to a true emergency, they do not need probable cause to enter a home without a warrant. That standard, the justices explained, belongs exclusively in the world of criminal investigations, the search for evidence of a past crime, not in life or death scenarios where someone may need immediate assistance. Instead, the court firmly reinforced the key rule from the 2006 Brigham City case. That rule states, police may enter a home if they have an objectively reasonable belief that someone inside is seriously injured or in immediate danger. It's a calculated middle ground. It's stronger than simple hunch or suspicion, but it's still far looser than the constitutional requirement of probable cause that traditionally protects the home. The court rejected Montana's attempt to apply a looser community caretaking standard. Simultaneously, they rejected Mr. Case's argument that probable cause should always be required in these situations. They made it irrefutably clear that life-saving interventions are fundamentally different from traditional criminal probes, and the Fourth Amendment must be interpreted with that distinction in mind. While the justices strongly disagreed with how the Montana Supreme Court reached its conclusion, using the wrong legal test, they agreed completely with the result. The officer's actions met the new, unified test of objective reasonableness. The entry was lawful, and the outcome, in the eyes of the highest court, was justified. In laying out the decision, the Supreme Court stressed the totality of the circumstances officers faced that day. They were responding to a call that explicitly suggested someone was armed, possibly suicidal, and potentially willing to harm police if they arrived. At the scene, they observed signs that significantly added weight to the concern. An empty holster, a notepad suggesting a note, and no response from inside the home after 40 minutes of repeated contact attempts. Taking all of that together, the history, the vague threat, the observations, the silence, the justices said the officers had something specific. It was not vague suspicion, but it wasn't concrete evidence of a crime either. It was an objectively reasonable basis to believe someone inside could be in immediate grave danger. And that, the court concluded, was enough. The court emphasized a powerful point. The Fourth Amendment does not require officers to stand idly on the sidewalk while someone may be bleeding out inside or while a dangerous mental health crisis unfolds behind a closed door. In those specific, urgent moments, they ruled, a warrant can wait. The justices rejected both extremes. They said reasonable suspicion was too flimsy to overcome the sanctity of the home, but probable cause was too strict when life is on the line. They firmly stuck to the middle ground, objective reasonableness. Quoting prior precedent, the court repeated its position clearly. When an officer reasonably believes someone inside a home is seriously injured or faces imminent harm, they may lawfully enter without a warrant. They unified the standard across the nation. So, while the justices disagreed with the method of the Montana court, they agreed the officers acted within the law, and with that, the ruling was finalized. This decision doesn't just finalize one case in Montana. It actively redraws the legal boundaries of how far the government can reach inside your home during an emergency. From now on, if officers believe but someone inside may be seriously hurt or in immediate danger, and that belief would seem reasonable to another officer in their position, they are permitted to enter without a warrant. This new standard touches every single household. It doesn't matter if you have never broken a law or if your name has never appeared in a police file. The legal bar for home entry is no longer tied strictly to criminal suspicion. It now rests almost entirely on how the moment looks through the trained eyes of law enforcement. The ripple effects of this ruling will reach far beyond Montana. Other pending cases across the country involving wellness checks, mental health crises, or potential domestic violence will now have to follow this exact same rule. Courts will ask whether the officer's belief was objectively reasonable, not whether they had probable cause to suspect a crime. That is why it matters. The replacement of probable cause with perceived safety is the ultimate erosion of the Fourth Amendment shield. The door is no longer just locked against investigators. It is only slightly ajar for intervention. What gets decided in court today could walk through your front door tomorrow. Thanks for watching, and don't forget to like and subscribe for more legal breakdowns. And remember, stay safe, stay smart, and never forget, knowledge is the ultimate defense. I'll see you in the next one.